Yeah. Charlie, would
Yeah.
you say a prayer for us, please?
I'd be happy to. Dear beloved Creator of all that is, we come together by your grace and our free will intention to move creation from an insidious descent into darkness by evildoers to a more goodly, godly direction. We come together by your grace and our earnest efforts to assist in the defeat of our enslavement and the destruction of our sacred planetary garden. It is all divine magic that you have given us the tools so we, as trusting innocents, can employ our God-given creativity with your guidelines, these being the principles of God's law, which are notated from scriptures as follows. A workman is worthy of his hire. All are equal under the law. Truth is sovereign. Truth is expressed in the form of an affidavit. An unrebutted affidavit stands as truth. An unrebutted affidavit becomes the judgment. All matters must be expressed to be resolved. Who leaves the battlefield first loses by default. A lien or claim is satisfied only through an affidavit. Sacrifice is the measure of credibility. And I finish with a quote from Chief Seattle. Man does not weave this web of life. He is merely a strand of it. Whatever he does to the web, he does to himself. Take only memories and leave nothing but footprints. All things share the same breath. The beast, the tree, the man. The air shares its spirit with all the life it supports. We are humbled by your grace.
Amen.
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 Thank you, Charlie. Thank
Absolutely.
you, Charlie.
Absolutely.
You're welcome.
So, we're missing Felicia, but let's go this way. Mike, would you introduce yourself? Tell us a little bit about yourself, and then we'll move on to Jeff. Then after that, as Felicia is not here, we'll move on to Brian. So would you start off, Mike?
Okay. Beginning in about 2012, 2013, I was nominated as Secretary of the Fourth Continental Congress. So I began networking that, and I met Brian through that effort of networking and rebuilding the militia structure across the country and trying to figure out what was actually going on. Because when I got involved in this project, I had no idea what was going on with the government or anything about the militia infiltration. So we've already covered a lot of the militia infiltrations through the last few years, and we've got solid commands that are networking now. And we're at the point now where it's time to start networking with the Jural assemblies, state Jural assemblies, grand juries, and the militia, and network them together, so we're all on the same page. And that's why I'm here now. And for the last 6 months, since I resigned as secretary, I've been working with Brian as part of his legal team for the California militia system.
Great.
Thank you. Jeff?
Yeah, my name is Jeffrey Bowen. I'm a state assistant with peoplesrights.com on the state of Arizona. And I also represent Sedona Creek Talk on YouTube. I am a regular guest here on local channel 11 with the Oregon Statewide Jural Assembly. And I think this is one of the most important shows that we've ever done to date. I think that the amalgamation of the militia and the civilian courts on all states in the union is the only chance that we have to move forward as a free people on the land.
Thank you, Jeff. Brian, would you speak to us, please?
My name is Colonel Brian Hunt. I'm the State Commander of Militia Forces California. I basically was appointed to that position 6 years ago, just before the Bundy Ranch operation took place, of which I was a participant in. I had actually brought in 3 of my units to stand with Clive and Bundy. And there's a report that came out 6 years after the fact that I was involved in writing on the things that I saw and heard while on that operation. I was the primary battlefield commander for that operation, and the powers that be that were involved, we had a lot of double agents, and there was a lot of infighting amongst the different groups that were there, including Blackwater, aka Craft International. So suffice to say, I wrote the report to address the problems that the militia faced. And part of that problem is we didn't have a JAG office, and we didn't have a provost marshal, and like the military. So being an arm of the military, we're not the military, but being an arm of the military, I looked into the California Military Veterans Code and the UCMJ and found that the militia is supposed to have a JAG office and a legal department and a provost marshal to enforce the laws in regards to how our people act and how they conduct themselves, and then to defend militiamen if they're picked up and taken to jail and having to appear in court. That's the whole purpose why we created JAG, and I put Mike pretty much in charge of our legal department right after he left 4th CC. And that's pretty much where we're at.
Thank you, Brian. I also like to thank you for providing my bona fides to the Oregon Militia. I met a fella in Salem the other day. He said you vouched for me, and I appreciate that.
Oh, you're welcome, Ron. I believe that's Colonel Colonel Thorne you met with. John Thorne?
Yeah, I guess so.
Yeah, we've been working very closely with Oregon Militia for the last 3 months. And we're working with other states, basically unifying the militia under a set of continental standards, as well as uniformed recognition of rank and file structure, as well as an award system.
I'd like to go over a couple of things with you, if you don't mind.
Sure, go ahead.
We found and we find that the United States is under a benevolent form of martial law and has been since 1861.
Yeah, I'm very familiar with that. That's called Executive Order 100, otherwise known as the Lieber Code.
Exactly. So you know exactly what I'm talking about.
Yeah.
The next thing is we found that ex parte Milligan is brought into effect if there is a civilian court on the land.
That I wasn't aware of.
Yeah, you can look it up. Jeffrey looked it up for us, as a matter of fact, came up with a ton of information, and it's all over the internet if you just look. And it specifically says, if there is a civilian court on the land, there cannot be martial law, period. That's according to their de facto ex parte Milligan Supreme Court of the United States. So
that's interesting. 30 years ago, Norman Olson touched on, and I'm wondering if he didn't find that. I'm referring to General Norman Olson of the Michigan Militia, formerly of the Michigan Militia, and he's now over the commander of Alaskan Volunteers. I'm wondering if he didn't find that early on, because when he went to address the floor of Congress at the 103rd Congress on terrorism and technology, he referred to that if the people understand their rights, martial law would not be possible in the country.
And that's exactly right.
So I'm wondering if he didn't know about it.
Is he working with Anna Von Ritz up in Alaska?
No.
He is not, no.
Okay. Let me finish. So we formed our civilian court. We looked it up. It takes 5 items, I believe it is, to form a civilian court. We executed that. Then we informed the feds, DOJ, FBI, U.S. Marshal Service, the state of Oregon, 36 sheriffs. We informed all kinds of people, including the provost marshal and the JAG officer of the Oregon National Guard,
Okay.
that we were Article 1, Section 1, which is all power is inherent unto the people, and that's us, and they acquiesced to it. Then we formed our civilian court, and we filed paper against Kate Brown. And when we called up the Attorney General of Oregon, one of her people laughed at me and said, you guys don't have a docket number, so you have no standing with us. Okay, so our petition for redress of grievance, according to the United States of America's Constitution, doesn't have any power with the Oregon Attorney General's office unless you have a docket number. And that was what she told me. So our civilian court met in Beaverton, and we filled out a document. Docket number 0407-1776. Williams got a copy of it. So we filed that second paper with Kate Brown's Attorney General, and then we included both our senators and Representative Suzanne Bonamici in the same paperwork for the same charges. They have violated their oath. They have no honor, therefore they cannot hold a position of trust. So we have that filed. They had 7 days, 14 days, and 21 days. And then we gave them another 30 days. So they acquiesced on that 4 different times, on 4 different time frames. And we have done that with several entities. The chief legal officer for the state and the chief police officer for the state of Oregon, the sheriff and the district attorney for Washington County, and then a Beaverton chief of police and the Beaverton city attorney. We filed on all of them so that we took care of the feds, we took care of the state, we took care of county and city, and they all acquiesced on it. All those documents are ready to go to our grand jury. Then Charlie and I were filing papers at the post office in Beaverton, and they excluded us from the post office for not wearing a mask. And that ricocheted back and forth on them pretty good. But the next day, we were right back with no mask and an apology from the postmaster. And we file our paper with Universal Postal Union's treaty, and file it with a round stamp into the post office, and it immediately is damn, I hate it when the word just goes away. They're immediately lawfully notified. So we've done that now with Post Office, the Veterans Administration, I don't know, maybe 10 or 15 others. They've all acquiesced on it. And all we're doing is waiting for a grand jury. We're
Question.
working. Go ahead.
I don't know if you guys know, but the recall for Governor Newsom is moving forward. We got enough signatures to remove him. My question is, once we remove him, because we tried to bring him to trial under the current court system, and the courts threw out our case on Gavin Newsom. So how do we form a court system that will be able to bring him to trial as a civilian, and not a member of the government once he's removed from office?
That's really quite easy. We've already done it, and I've set the templates up. I spoke with Mike about that the other day, and I'm trying to get a hold of all of the militia, and I'm already working with peoplesrights.org to reach all of their state assemblies so that we can institute a civilian court. We know what it takes. We have done it. It's a fact. And we need to do that 49 more times in every state. We have the civilian court, and then it's a 21-day process to make them acquiesce or stand and deliver. And as yet, we've never had one stand and deliver. They always acquiesce, they fold. So I believe that in a minimum of 21 days, you can have a civilian court ready for a grand jury. And if you had 45 members of the grand jury pool signed up, on the 22nd day, you could open a grand jury and get a true bill against Newsom. And if you had 45 members the next day, or even that afternoon, you could have a Seventh Amendment jury trial ready to go.
Ron, can I say something?
Sure.
Okay. How many militia members are on the state of California?
Well, what I can tell you, we have possibly 86 units. How big those units are, we don't know. What I do know is I have people that I trust.
Approximately in a unit, what's a rough number on the low end?
Well, again, we don't discuss numbers.
I get it. That's fine.
To our
let's just say this. Let's say there's a whole bunch of them. How about that?
Okay.
Does the state of California militia discuss matters, or are they in conversation with the militia in the state of Arizona?
I am in touch with Arizona. I do have people that I communicate with in Arizona from time to time. Communications is spotty at best right now with Arizona, but we are working on that.
So what Ron's talking about is absolute truth and 100% a game changer, and it's the only way there really is, and it's legitimate. The problem is getting 45 people. First of all, you got to create the California Statewide Jural Assembly. Okay, that takes about 6 to 8 people. Second of all, you got to create a grand jury. You're going to need about 45 individuals to create a grand jury.
It was my understanding that a grand jury was 21 people.
It is, but is all 21 going to have COVID, or somebody going to be sick? Is somebody going to be in jail? You got to have 45 to be able to make damn sure that you can show up and perform that 21. So you got to have literally almost a double alternate situation. So any given day you can hold court. That's why the 45 number exists. So
okay.
The reason that there's multiple reasons for Ron's Oregon State, we'll just use Ron as an example, the Oregon Statewide Jural Assembly to join with the militia, because the Jural assemblies don't have a police force. They don't have a military. So they need force. They need somebody who's going to show up and say, look, this is what we're doing. Okay. Now, if you're going to have what needs to happen to get Newsom out of there, you're going to have this form, and it takes numbers. It takes commitment, and it takes dedication. The militia, they seem to have the numbers, they seem to have the commitment, and they seem to have the dedication. Do they have the balls?
Well,
I think it's more the organization.
Go ahead and elaborate on that. I'm open. I'll let you talk.
I asked Brian to create the analysis and report was to expose all the confidential moles and informants and people that were buried throughout the militia system that were keeping it from unifying. Like Brian was saying, in California, there's at least 89 different units, but they're not all under one command. And that's the purpose of the Continental Militia System, is to restore or create. Basically, the militia was abandoned after the Civil War, and there's nothing really on paper except what the government puts out. So what we've been doing is filling in the missing links and creating the certification process to create to authorize and certify state commanders, county commanders, regimental commanders, so on and so forth, and flesh out the total command, because we're basically reinventing the wheel from scratch. And that's part of why we're working with Oregon. There's a commanders conference that goes on bi-weekly now, and it's been going on for several months, and there's about 8 state militias involved, including Maine and Wisconsin now, which is kind of interesting. But a lot of the states don't have state commanders, and that's part of the problem too. And everybody's kind of hiding under the sheltering in place and hiding from the government. But we're past all that, and it's slowly coming together. It's just such a huge project. Like this call tonight. Look how many hours this took.
So what I read, I would like you to correct me if I'm wrong. I'll make this brief. I read that the President of the United States of America was the commander-in-chief of the militia.
He's the commander-in-chief of several militia when called into active duty, or when called in for an emergency. But he cannot use a militia, let's say, to collect weapons from the civilian population. He can't use the militia, which is a civilian arm. It's not the National Guard like everybody thinks it is, but the militia cannot be used in any way, shape, or form. Even a governor can't use the militia to violate the rights of citizens.
Right.
And that's the difference between us and the military.
And so from what I understand is that states did not like this, the fact that the President of the United States could call on a civilian militia. And so states started implementing the National Guard as a workaround to subvert the power of the militia.
Well, you're half correct there. It was Woodrow Wilson in the First World War that took the militia and created what's known as the Dick Act of 1810. And
1910.
1910, excuse me. Because what they want to do is they needed an armed force to go overseas to Europe and beat up on Germany. Well, at the time, the U.S. military was small, and so they decided, we can send the militia. Well, the Constitution says you can't, because we can't be sent overseas. Well, they created the National Guard. They stripped the militia, put the militia in the National Guard, sent them overseas. A federal judge in 1912 determined that Woodrow Wilson violated the law when he did that.
So what became of that? Did anything become of it?
Well, the federal judge in 1912 ruled that Woodrow Wilson was wrong, that it was an impeachable offense, but nothing ever came of it.
Okay, thank you guys. We'll have to resume this for next week's show. We're terminating this one, part 1. And thank you, Mike. Thank you, Brian. Thank you, Jeff. Thank you, Charlie. Of course, you're my boss, so that's how it goes. Thank you, William. And that's it for tonight.
Thank you, Ron.
I'd like to introduce to the stage Ron Vorman, Oregon Statewide Jural Assembly. He's been waiting patiently, has important words for everybody.
Hello, we're in the first tent over there. It was loaned to us. We're signing up people for a grand jury. The way we think we have to do this is we must form a grand jury, bring a true bill to a Seventh Amendment trial jury, and try these people. And we've already served them the papers, and they've acquiesced to it. So what is required is 45 people to stand in their own name in a grand jury and provide a true bill against Kate Brown, Suzanne Bonamici, Jeff Merkley, and Ron Wyden. We served these people months ago with the paperwork saying that you have broken your oath, you have no honor, and you cannot hold a position of trust. And we served them with these papers. They had 21 days to acquiesce. We were told we didn't have a docket number, so we have a court, so we gave them a docket number and gave them 30 more days. They've acquiesced. They have no honor. Therefore, we have the documents ready for a grand jury. We need a grand jury of 45 people to have a large enough pool to have 25 people that will stand in their own name and actually vote a true bill to a jury trial to try this person. We now have the documents ready to go to all of the above, DOJ, FBI, marshals, Kate Brown, Ellen Rosenblum, 36 sheriffs, so all of them, saying that the Oregon Statewide Jural Assembly, that's us, we have formed the Second Amendment militia, which is what is required by the Constitution. You just can't go out here and say, I'm a militia, because then you become something other than what is constitutionally required. So when we get this